Guys, I'm showing a little after 9. Are we ready to tackle this?
Yes, Chairman.
All right. Good morning, all. This meeting is called to order. Mr. Trobman, has anyone signed up for public comment?
Morning, Commissioners. We did receive one request for public comment. Cassandra Camargo, if you're on the line, if you could unmute yourself and introduce yourself for the record. Not sure if Ms. Camargo has been able to join us. And that was our only request for comment this morning.
All right. Thank you, Mr. Trobman. Good morning, Ms. Miller.
Good morning, sir.
Let's see. Let's tackle agenda item 3, but we have no cases to reconsider under agenda item 3. Is that correct?
Yes, sir. No cases.
All right. We'll move to tax liability cases under agenda item 4. We have no cases on docket 2.
That's correct, sir.
No fair housing cases under agenda item 5.
No, sir. No cases.
Well, how about agenda item 6?
We have none pulled, but let me send you the short form dissent list here. There we go.
All right, I move we accept staff recommendations on the remaining wage claim cases on docket 2.
Chairman, I second the motion except for those cases on which I am dissenting as reflected on the wage claim short form dissent list for docket 2.
And I concur with the chairman's motion, except for the cases on which I'm dissenting, as reflected in the wage claim short form dissent list for docket 2.
This motion passes with the exceptions noted.
Thank you.
Let's move to agenda item 7, consideration of unemployment insurance cases. On docket 2, please proceed when you're ready.
Thank you.
Case number 2523699. Commissioner Alvarez.
The AT2 decision is not supportable. The claimant did not participate in the AT1 hearing because the notice for the hearing did not arrive in his mail until 5 days after the hearing date. He was unaware of the hearing and did not know to call in for it. The claimant established late receipt of the notice of hearing by credible and persuasive evidence and the good cause for his non-appearance. Reverse the AT2 and resubmit on the merits.
I would affirm the AT decision regarding good cause. The claimant could not recall if he was out of town when the hearing notice was mailed to his address of record. The claimant also could not confirm whether the mail was checked during the 2 weeks period prior to the hearing or when the notice was placed in his mailbox. Since the claimant has not provided credible and persuasive evidence of delayed delivery, he has not established good cause for his non-appearance. As to the merits, the claimant quit rather than comply with the reasonable request to pay for the damaged equipment. The claimant did not deny fault for the accident that led to the damage, and he was given notice upon hire that he would be financially responsible for such at-fault accidents. Thus, when the claimant quit, he did so without work-connected good cause, and we should affirm the AT2 decision. The claimant did not have good cause for his non-appearance, voluntary leaving, no chargeback.
Reverse the AT. Claimant established good cause for AT1. Resubmit.
Thank you. We will resubmit the case.
Case number 2582824. Commissioner Alvarez.
The AT decision should be reversed. The claimant stopped work when she was hospitalized due to complications with her pregnancy. She gave birth, but thereafter she continued to have complications and multiple surgeries. She was unable to return to work with the employer, and she filed for unemployment benefits effective April 21st, 2020. She was not able to return to work until her last surgery on May 25th, 2020. The claimant therefore voluntarily left the job due to medically verified illness. Modify the AT, no voluntary leaving, no chargeback due to MVI, void adequate response ruling, and memo to UIOs and CS to investigate whether the claimant was able to work through May 30th, 2020.
AT decision should be modified. The claimant refused to return to work due to fear of contracting COVID-19, which is a personal reason. Furthermore, the claimant did not request any accommodations prior to filing for benefits, nor did a doctor advise her to resign. The claimant quit without work-connected good cause, and we should modify the AT decision. Voluntary leaving, no chargeback, sever adequate response.
Modify the AT, no voluntary leaving, no chargeback MVI, void adequate response, memo to UIO and CS to investigate claimant's ability to work.
Short form.
Yes, sir, Commissioner Demerson.
And also, we agree with a memo to UIO and CS to investigate the claimant's ability and availability for work.
Yes, we will send the memo.
Thank you.
Case number 2601342, Commissioner Alvarez.
The claimant's motion for rehearing offers medical documentation to show that she has a medical condition that puts her at higher risk for COVID-19 related complications, and as such, shows she had good cause to quit. This documentation was not provided earlier because the claimant was not informed by TWC that she needed to provide medical documentation. Therefore, the claimant's MR meets the 3 requirements because it offers new evidence, provides a compelling reason for not providing it previously, and explains how the new evidence will change the outcome of this case. Grant the claimant's motion for rehearing.
The claimant did not actually provide any new evidence in their MR. As such, we deny the claimant's motion for rehearing.
Deny the motion for rehearing.
Short form dissent.
Yes, sir, Commissioner Alvarez.
Case number 2607475, Commissioner Alvarez.
The decision should be modified. The claimant filed a valid claim. Regarding the job separation, the claimant was hired to work a 10-hour shift, 4 days a week. However, he ended up working much longer shifts, 6 days a week. The day before he was discharged, the claimant worked from 1 p.m. to 4 a.m. He was supposed to get off of work at 11 p.m., but had to work late due to staff shortages. Working until 4 a.m. caused the claimant to be overly fatigued the next day, and he arrived to work late. However, he called the employer to provide notice that he would be late. As the claimant's tardiness was caused by the excessive hours that he was working, the claimant's tardiness did not rise to the level of misconduct. Modify the AT valid claim, no misconduct chargeback.
The AT decision should be modified to sever the valid claim issue. On the job separation, the claimant was on a final warning for attendance when he was an hour late to work on the final incident date. The claimant made no attempt to arrange a later start time for his next shift, nor did he try to explain the circumstances to management upon his late arrival to work. The claimant did not take adequate steps to protect his job and his position of employment. We should modify the AT decision, misconduct, no chargeback, sever the validity of the claim issue.
From the AT, valid claim, misconduct, no chargeback.
Ms. Miller, short form dissent.
Yes, sir, Commissioner Alvarez.
Case number 2615671, Commissioner Demerson.
The AT decision should be modified. First, the valid claim issue should be severed. As to the job separation, the evidence indicates that the employer's business was severely impacted by the pandemic. The employer had to release its Houston employees due to a diminishing budget and offered the claimant a position there for a few weeks. The claimant declined due to his fear of COVID-19. The claimant was subsequently let go, and the preponderance of the evidence supports that the claimant was laid off due to a lack of work. Since this lack of work appears to be the result of the COVID-19 pandemic, the claimant should be qualified for benefits and the employer's account protected from charge. Accordingly, we should modify the AT decision, no misconduct, no chargeback, disaster, sever the validity of claim issue.
Chairman, I'll agree with Commissioner Demerson.
Agreed.
Thank you. We have a unanimous decision.
Case number 2620375, Commissioner Alvarez.
The decision is not supportable. The mediated settlement between the parties specifically stated the claimant was to be terminated. The employer's decision to discharge the claimant as a condition of their settlement was the cause of job separation. The employer could have allowed the claimant to continue working, but chose to discharge him instead. The employer has not presented any evidence to establish misconduct. As such, the claimant should be qualified for benefits, and the employer's account should be subject to charge. Even if the job separation were analyzed as a quit, the dispute arose from the employer allegedly discriminating against the claimant and demoting him. As such, the claimant would have good cause to to separate from employment rather than continue his demoted position. Reverse the AT, no misconduct chargeback.
The appeal tribunal decision should be affirmed. The claimant stated that he would still be working for the employer had the employer not demanded the claimant agree to leave his position as part of the arbitration. This indicates that the claimant could have elected to continue working had he chosen to reject the settlement agreement outright. As such, the claimant resigned for the personal reason of securing a settlement agreement, and in so doing, quit without work-connected good cause. We should affirm the AT decision, voluntary leaving, no chargeback.
From the AT, voluntary leaving, no chargeback.
Short form dissent.
Yes, sir, Commissioner Alvarez.
Case number 2625248. Commissioner Demerson,
We should affirm the appeal tribunal decision. Due to concerns that employees were not following health and safety guidelines, the claimant approached the employer. The employer took action and swiftly resolved the claimant's concerns. Thereafter, when employees began ignoring the safety protocols, rather than taking the matter to the employer as before, the claimant resigned. The employer had resolved the claimant's former dissatisfaction, and there was no indication that the employer would dismiss the claimant's newest concerns. Thus, the claimant quit due to fear of being exposed to COVID-19 and without giving the employer an opportunity to remedy the current issues with his coworkers' behavior. The claimant quit without work-connected good cause. We should affirm the AT decision, voluntary leaving.
Could I have that case repeated again?
That's case number 2625248.
Chairman, can I take a break really quick
You bet.
so I can locate it? Thank you, sir. Chairman, I apologize for the inconvenience. Can we come back to that case? I misplaced it, so I'm going to need to look for it.
Absolutely. Commissioner Pearson, you have any objection to that?
None at
you.
all.
All right.
continuing case number 2630204. Commissioner Alvarez,
The decision is not supportable. The claimant has provided documentation showing she suffers from a medical condition. Her condition was made worse by the increased stress posed by the pandemic. The claimant's doctor advised her to continue her medication and take leave. Since the claimant had exhausted all available leave, she resigned. The claimant was unable to seek other alternatives due to her medical state. Since the claimant's separation was the result of her medical condition, she should be qualified for benefits. Reverse the AT, no voluntary leaving, employer billed, and send a memo to UIO and CS to investigate whether the claimant is able to work.
The appeal tribunal decision should be affirmed. The claimant cited medical issues as the reason for resigning. However, the claimant did not take adequate measures to protect her job. Indeed, the claimant stated that she did not request unpaid leave or any alternative leave that might have been available. Moreover, the claimant stated that she did not bring her concerns to the employer. In addition, the employer stated that it provided PPE, which included hand sanitizer, wipes, and masks. Since the claimant did not make a reasonable effort to protect her job, and since she did not provide the employer an adequate opportunity to address her concerns, her resignation was without work-connected good cause. We should affirm the AT decision, voluntary leaving, reimbursed employer not billed.
Affirm the AT, voluntary leaving, reimbursing employer not billed.
Ms. Miller, short form dissent.
Yes, sir, Commissioner Alvarez.
Case number 2649851, Commissioner Alvarez.
There was no dispute between the parties that the claimant was furloughed for 1 week from May 17, 2020 to May 23, 2020. Whether the claim should be backdated to the week he was furloughed has not been addressed. The claimant has indicated he encountered difficulty when he tried to file his claim. This case should be reheard to address whether the claim should be backdated.
The AT decision is supportable under the facts presented. Although he was unemployed during a temporary furlough in May 2020, he did not file an initial claim until a few weeks later, after he had returned to full-time employment. He was not unemployed when he filed his initial claim. The reasons he gave for not filing his claim earlier were not compelling. There is no evidence that anyone gave him misinformation or that he was prevented from filing his claim due to reasons beyond his control. Without such evidence in the record, there is no basis for a finding that he has shown good cause to backdate his initial claim. Accordingly, we should affirm the AT decision. The claimant was not unemployed when he filed his initial claim, and so his claim was invalid.
Reverse the AT valid claim, memo to UIO and CS to investigate backdating the IC to May 17, 2020.
Short form, Chair.
We have not yet received a majority vote. We've got 3 different votes. Commissioner Alvarez?
I would agree with the chairman on this particular case.
Thank you. We'll reverse and send a memo.
My short form.
And I have your short form dissent, sir.
Thank you.
Case number 2661229, Commissioner Alvarez.
The AT decision is not supportable. The employer was subjected to extreme financial upheaval as a result of the pandemic. The claimant agreed to a reduction in pay so the employer could continue operations. Layoffs, nevertheless, were imminent, and the employer the employer offered employees, including the claimant, a severance package that included a fraction of her pay and insurance benefits for a period of time. If the claimant did not accept the package, she was risking being laid off with no benefits. The claimant accepted the agreement. The reduction in the claimant's pay and the risk of imminent layoff without benefits gave the claimant good cause connected with the work to voluntarily leave the position. Since the claimant's separation was a result of the pandemic, the employer's account should not be charged due to the disaster. Modify the AT, no voluntary leaving, no chargeback due to the disaster.
The appeal tribunal decision should be affirmed. The claimant elected to participate in the employer's voluntary leave of absence program, which, judging by the claimant's testimony, contained certain benefits, including a percentage of her pay and insurance coverage. The claimant stated that she could have continued to work had she not accepted the benefit package. Therefore, the claimant resigned while work was still available in order to participate in the employer's voluntary leave program, which is a personal reason without work-connected good cause. We should affirm the AT decision, voluntary leaving, no chargeback.
Affirm the AT voluntary leaving, no chargeback.
Short form dissent.
Yes, sir, Commissioner Alvarez.
Case number 2680811, Commissioner Demerson.
We should reverse the appeal tribunal decision regarding timeliness of the employer's appeal. First, we should consider the entirety of the appeal period fell within the window of time that TWC was experiencing technical difficulties. Second, the employer completely shut down as ordered by the governor's executive order, which prevented the employer from accessing its mail for an extended period of time. Third, the employers appealed within days of being able to safely retrieve its mail and did not sit idly by, as has been suggested. Finally, we should note that during last week's docket, a claimant who alleged everything being shut due to COVID-19 was granted timeliness of her appeal. Under these circumstances, we should deem the employer's appeal timely and resubmit the case for merits testimony.
The decision should be affirmed. The employer claims that the stay-at-home orders prevented it from timely appealing. The employer delayed appealing until under a month after the stay-at-home order was lifted. The employer's appeal was late. Affirm the AT, late employer appeal, bill reimbursing employer.
Affirm the AT, untimely employer appeal, bill reimbursing employer.
Form dissent.
Yes, sir, Commissioner Demerson.
Thank you.
Case number 268 8014, Commissioner Demerson.
We should reverse the appeal tribunal decision. The claimant was separated after the employer was required to close due to state law, which prohibited the employer from continuing conducting business after July 4th, 2019. Because the employer was required to shut down as prescribed by law and was unable to continue to employ the claimant, the employer's account should be protected from charge. This case is distinguishable from the court case having to do with the racing track, unlike a racetrack, which has jobs that could be performed year-round. A fireworks stand has no other work that a fireworks seller could possibly perform. We should reverse the AT decision, no chargeback, separation caused by operation of law.
The decision should be affirmed. The claimant worked a seasonable position and was laid off at the end of the season. Therefore, the employer should be charged. Affirm the AT and chargeback.
Reverse the AT, no chargeback.
Short form dissent.
Yes, sir, Commissioner Alvarez.
Case number 2690803, Commissioner Demerson.
We should grant a rehearing in this case. Because the employer's first-hand witness was not available to testify at the hearing due to a conflict, we should rehear the case for testimony from this witness.
The decision should be affirmed. The claimant was the only party providing first-hand testimony. His sworn testimony that he was laid off due to the lack of work carries greater weight than the hearsay allegations that the absence without notice. The evidence fails to establish misconduct. A rehear is not appropriate in this case. The employer has failed to provide any details regarding why the witnesses were unable to appear or which witnesses it intended to present. Furthermore, this job separation occurred almost a year ago. The employer provided a single sentence response during the initial investigation and in each of its appeals, and has never in all of this time even stated the date that the claimant was supposedly absent. The employer has given ample opportunity to provide information regarding this job separation, and they have chosen not to do so. Affirm the AT, no misconduct, chargeback.
Modify the AT, no misconduct, chargeback, void adequate response.
On a short form,
Commissioner Alvarez, do you agree with the chairman's vote to void the adequate response ruling?
Yes, I agree with the chairman.
Thank you very much.
No, thank you.
And Commissioner Demerson, I have your short form dissent.
thank you, Sherry.
Thank you.
Case number 2690972, Commissioner Alvarez.
The AT decision is not supportable. The claimant was a commission-only auto sales rep. He left the job when he no longer was able to earn any commission from his work. After a turnover in management, internet referrals were no longer given to the claimant. The vast majority of the sales came from the internet sales. And as a result, the claimant could not earn a living wage for weeks. He quit as a result. The claimant's inability to earn a living wage as a result of the change in the employer's working conditions gave the claimant good cause connected with the work to quit. Reverse the AT, no voluntary leaving chargeback.
We should affirm the appeal tribunal decision. While the employer's management may have undergone some changes, the claimant's job duties and pay structure remain the same. Thus, the claimant quit without good cause connected with the work. We should affirm the AT decision, voluntary leaving, no chargeback.
Reverse the AT, no voluntary leaving, chargeback.
Short form dissent.
Yes, sir, Commissioner Demerson.
Thank you.
So that was the last case, except for the one that we need to return to.
Chairman, I found the case
Right,
and I'm ready to read it if that's okay.
perfect.
So this is case number 2625248. Commissioner Demerson, would you mind restating your vote?
Affirm the AT decision, voluntary leaving.
Okay. The decision should be reversed. While the employer set up COVID safety precautions, the employees were not following these precautions. The claimant complained and the situation improved temporarily. However, the employees once again went back to not following the safety precautions. As the failure to follow these safety precautions created a safety issue that put the claimant's life at risk. and as the employer failed to remedy the situation despite the claimant's complications, the claimant had good cause to quit. Reverse the AT, no voluntary leaving.
Reverse the AT, no voluntary leaving.
Short form.
Yes, sir, Commissioner Dimerson, I have your short form dissent.
Thank you.
So those were all of the UI cases pulled for discussion on docket 2. The short form dissent list for the UI cases was previously submitted.
I'll move we accept staff recommendations on the remaining UI cases on docket 2.
Chairman, I as well I second the motion except for those cases in which I'm dissenting as reflected on the UI short form dissent list for docket 2.
I concur with the chairman's motion, except for the cases on which I'm dissenting, as reflected in the UI short form dissent list for docket 2.
The motion passes with the exceptions noted.
Thank you very much.
Thank you. That brings us to the end of agenda items 3 through 7. Mr. Trobman. Am I understanding that our commenter has joined the meeting?
Yes, Chairman, Commissioners, I believe that Ms. Camargo has joined the meeting. Ms. Camargo, if you're able to unmute yourself, introduce yourself for the record, and provide your comment.
Hi, this is Cassandra Camargo.
Good morning.
Good morning. How are you?
Go ahead. Yes, good morning. Doing well. Please proceed.
Okay, I wanted to speak on behalf of the TRS changes that we have coming up. We've got a couple of different issues that we're having with that. We're having, the pre-star. If we have to do the pre-star, does that mean that we come off of TRS? Does it mean that we come off of CCS and lose our CCS contract if we have that issue? Like say some of the some of the items that are on that pre-star registration list, like say for example, they've got CPR and first aid on there. There may be you've got a new employee, it may have fell through the cracks, it was an accident, it was oversight, and you get that citation, that automatically takes you off of that pre-star, which then loses your funding. And so if we lose our funding, do we also lose our CCS funding? Because we lose our additional TRS funding, but do we lose our CCS funding? And so that is a concern for us here. Another issue that we have is, some of the wording that we are changing to in the TRS guidelines is things like we've got to use never. And so the wording is a lot stronger and a lot different, but also creating some gray area if you continue to read through some of those things. Another thing that we're having an issue with is that the 25%, the additional 25%, this is not TRS related, but the additional 25% that we were receiving for COVID during the COVID times ended in on December 31st of 2020. And so we are now not receiving that additional 25% on our funding anymore. And so that value has dropped. And so we're trying to get that uplifted and upheld or even brought back. That 25% is something that we're looking at as well. Sorry, I'm trying to cover everything in a short time span. The biggest ones was like the pre-star and then some of the citations that are on that pre-star registration form that brings concern for us just because as a center, as a facility, I mean, that gives no room for the error that may come from some of that. And it's just not feasible for all schools. As you look through majority of schools here in town, I know that we're trying to bring the level of education up and bring that that push for that level of quality of care up. But this is giving us no room to breathe within some of this because, it's paperwork error is a lot of those things. And paperwork error is a struggle as you can't always get it 100%. And so you miss that 1% and you're now off TRS and you're losing that value and that money within your school. I really think that that's all I have for now.
Right. Thank you very much.
That brings us to the end of the public comments today.
Thank you very much, Mr. Troman. Commissioners, let's pause for a few moments just before we tackle agenda item 8. We'll take a quick break.
I would got nervous. Huh?
Okay, we're ready to tackle the rest of this. I'm not showing anything on agenda item 8. Let's move to agenda item 9, discussion consideration possible action regarding the evaluation of the effectiveness of the child care program report for fiscal years 2019 and 2020 for submission to the 87th Texas Legislature.
Good morning, Chairman, Commissioners, Mr. Cerna. For the record, I'm Reagan Miller with the Child Care and Early Learning Division. Section 302.0042 of the Texas Labor Code requires TWC to submit a report to the legislature no later than January 15th of each odd-numbered year on the effectiveness of TWC's child care program. The statute requires us to report on the wage and employment status of parents receiving child care, improving the training of child care professionals, and how we are collaborating with TEA, Head Start, DFPS, and HHSC. The statute was also amended last session, directing TWC to provide additional information and data on Texas Rising Star and how our payment rates allow providers to provide high-quality child care and also ensure that TWC meets our legislatively established performance measure on the number of children served per day. In the summary section of the report on page 1, we noted that we have increased the number of Texas Rising Star quality rating child care providers almost 64% since 2015, and that subsidized child care is a critical economic support which allows families to enter and remain in the Texas workforce. We see that 86% of TANF parents found employment within 12 months of receiving child care, and 86% of non-TANF parents maintained employment 12 months after receiving child care. Today, we're seeking your direction on approval of the Child Care Effectiveness Report for submission to the Texas Legislature and ask for the ability to make any needed technical corrections prior to submission. I'm happy to answer any questions.
Any comments or questions?
No comments here, Chairman.
None here, Reagan. Just appreciate you guys continuing to work in this space. It's very, very important for our Texans.
Do we have a motion?
Chairman, I move that we approve the report as presented by staff.
Second.
It's been moved and seconded. Vote unanimous. Thank you. I'm showing the staff does not have anything to present under agenda item 10. I'm showing that under item 11, Mr. Cerna, what do we have here?
I don't believe we have anything under item 11, sir.
Nothing under item 11. Staff does not have anything to present under 12. Is there a legislative report today?
Yes, there is. Good morning, Mr. Chairman, Commissioner Alvarez, Commissioner Demerson, and Mr. Cerna. For the record, Michael Brick, Governmental Relations. Last Friday, Representative Hubert Vo agreed to file TWC's legislative proposal related to Fair Housing Act amendments in the Texas House. We do not yet have a bill number on that bill, but we'll update you as soon as we do. Also today, the 87th Texas Legislature convenes at noon. Both the Texas House and Senate are expected to consider their rules later this week. And as these rules are adopted, they will outline how the chambers will be operating this session. And that concludes my remarks. I'm happy to answer any questions you have.
Any questions?
None here, Chairman.
None.
None. Thank you very much.
Thank you.
Mr. Stern, anything else on the executive director's report?
The only thing I have to report is unfortunately that we've lost 2 employees in 2021 to COVID-19. Both had been teleworkers, so there was no further exposure, but unfortunately we lost two of our employees, one in unemployment insurance and one in vocational rehabilitation services. So our thoughts and prayers go out to those individuals and their families. Other than that, I have nothing else to report, sir.
Absolutely. Thank you for bringing that to our attention, Mr. Stern. Is there any other order of business to come before the commission today?
Chairman, I'd also like to acknowledge that we lost a close friend that's worked closely with the Texas Science and Engineering Advisory Board, who we lost recently, who was committed to making sure that we provided every young Texan with an opportunity to learn and advance their science and technology. So it was sad to hear that our chairman recently passed away from that. And I also wanted to state that I'm looking forward to working with you and Commissioner Demerson in the upcoming legislative session.
Thank you, Commissioner Alvarez.
Chairman, I'd like to echo Commissioner Alvarez's sentiments. I had the privilege in my prior position of working with Truman Bell, ExxonMobil, and their on support of our science fair efforts over the years. And Truman was a true champion in that space in big ways. And so we appreciate ExxonMobil generosity towards our science fair efforts. I look forward to carrying on those efforts down the line, but he will be sorely missed and was a champion for those students in that science.
Yes, Chairman Truman Bell was a great man and a great loss to the state of Texas. So just wanted to acknowledge that.
Thank you for doing that, Commissioner Alvarez, and as before stated, the opportunity to work with Truman in big ways, and Emily Clodfelter, Lawley over there. Truman will be missed. UTSA and Texas A&M University now is very involved and engaged with the science fair, but will be a hard one to replace.
Thank you.
Thank you.
Anything else? Is there a motion to adjourn?
Nothing else, Chairman.
All right. Is there a motion to adjourn?
Oh, yes, sir. Chairman, I move that we adjourn.
I second that motion.
It's been moved and seconded to adjourn, and we're adjourned. Thank you. Thank you, everyone.
Thank
Have a great day, everyone.
Hello, gentlemen.